All right. Thank you, everyone, for coming out today. My name is David Hutchinson. I'm the Vice President of Programming for the Texas Federal Society. The Federal Society is a national legal organization which is committed to conservative and libertarian values. There's a lot more I can say about the Federal Society. If you're interested in hearing more about the Federal Society, come grab me or come with a name tag after the event, and we'd be happy to tell you more and we get you on the email list. There's a lot that we want to talk about today in this very interesting debate, so I'm going to turn it over to Stefan to introduce our speakers for today.
Hey everyone, I'm glad y'all are here. We expect this to be a real fun one. Our guest here today is Mr. Josh Blackman. Mr. Blackman is a national thought leader in constitutional law at the Supreme Court. 2012, Mr. Blackman served as professor at the South Texas College of Law. And Josh is also the president of the Harlan Institute and founded Fantasy SCOTUS. Our other participant is UT7 Steve Vladeck. Mr. Vladeck holds the Charles Allen Wright Chair in Federal Courts at our law school. He's also a nationally recognized expert on constitutional law and federal courts. He is the CNN Supreme Court analyst, and he's a co-author of Ask the Publisher's leading national security law and counterterrorism law casebooks.
All right. Thank you so much. It's a pleasure to be here at UT. Always my good friend Steve. We don't agree on much, but we always debate civilly.
No,
usually.
We don't.
And that's why we have fun. It's kind of like it's a shtick. We've done this before. So in the span of 2 years, the Supreme Court decided two landmark Second Amendment cases. DC v. Heller in 2008 held that the Second Amendment guarantees an individual right to keep and bear arms that is not connected to malicious service. And McDonald v. Chicago, 2010, applied this right to the states through the 14th Amendment. The precise holding of these cases, however, was limited to the issue of whether federal and state governments could prohibit the private ownership of handguns inside the home. Heller and McDonald did not address a broader question. Does the Second Amendment guarantee a right to carry a firearm outside the home? Over the ensuing 12 years, the lower courts would divide on this question. In New York State Rifle and Pistol Association versus Bruin, 2022, the Supreme Court held that the Second Amendment does protect an individual right to keep and bear arms outside the home. Who are these people? Brandon Koch and Robert Nash were law-abiding citizens in upstate New York, Rensselaer County. They were members of the New York State Rifle and Pistol Association. Koch and Nash both wanted to carry a handgun outside the home to defend themselves. New York required more. Specifically, applicants had to demonstrate they had, quote, proper cause, that's the word in the statute, to carry a firearm. That is, they needed a special need for self-defense that can be distinguished from the general community. It was not enough to show they lived or worked in a high crime area. Rather, they had to provide evidence of particular threats, attacks, or extraordinary danger to personal safety. New York had what was known as a may issue regime. That is, the state may issue a license at its discretion. By contrast, more than 40 states have a shall issue regime, which means the government will give you a license so long as you meet certain background checks and objective criteria. Some states have what's called constitutional carry, Texas, which doesn't even require a permit at all. Koch and Nash did not have a special need that could be distinguished from the general community. They simply wanted a firearm for self-defense. Therefore, a judge determined that they failed to demonstrate proper cause, and the lower courts upheld the denial of their permit. This case went to the Supreme Court. It was reversed by a 6-3 vote. Justice Thomas wrote the majority opinion. It was joined by the Chief Justice and Justices Alito, Gorsuch, Kavanaugh, and Barrett. Breyer wrote the dissent, which was joined by Justices Sotomayor and Kagan. So I think there were 5 major issues I want to talk about today that we'll probably get into throughout the course of our event. The first is methodology. Right? How do you decide a case involving the Second Amendment? In the decade following Heller and McDonald, lower courts often reviewed gun laws with strict scrutiny or intermediate scrutiny or some type of scrutiny that was familiar to law students. Justice Thomas's opinion at least appeared to reject any means and balancing, at least by name. He said the court favored a test rooted in the Second Amendment's text, as informed by history. Is this originalism? We'll talk about that later, but that's the test he has: text, and history. Now, when you have this test, who has the burden? Is the burden on the citizen to show that there is historical justification for the right? Or is the burden placed on the government to show that the regulation is part of historical tradition? The latter. Thomas wrote that the burden is on the government to show that that its regulations is part of a historical tradition that delimits the bounds of the right to bear arms. Okay, so again, the government has the burden to show the regulation fits in history. It's not the burden of the citizen to show this. Okay. Then the court will assess whether the modern regulation is consistent with the Second Amendment's text and historical understanding. Now, this was a disputed point. Justice Breyer in dissent wrote that judges are not equipped to resolve historical questions or to perform searching historical surveys. Indeed, during the arguments, Justice Breyer said that Heller is in doubt, that historians at departments of English and departments of history have contested Heller, saying it's not a correct reading of the English Civil War, and so on. Justice Sotomayor, at argument, said that history and tradition is that states get lots of deference. Even in the wake of Bruin, we've had a district judge in Mississippi say maybe we should appoint a federal, an expert to advise us on historical matters. Judges in the Fifth Circuit have said, how are we supposed to do this? We are not historians. To that, Justice Thomas said, too bad. He said, courts resolve legal questions rather than resolve historical questions in the abstract. And when the parties present courts with historical record, courts can decide the case based on which party made the stronger case. Okay, so we'll talk about methodology, I'm sure, later. All right. Second, the court held that the Second Amendment protects a right to carry a handgun outside the home. New York didn't actually dispute this point. The word bear has to have some meaning. But New York argued that its Mace regime was valid. Justice Thomas said that the Second Amendment does not draw a distinction between the house and the public. Bear, he wrote, naturally encompasses public carry. And if you confine the right to bear arms to the home, it would nullify half of the Second Amendment's operative protections. Right? More of a self-defense can take place in the home or outside the home. Again, this point wasn't seriously contested. The more contested point was whether the proper cost standard of the Mace regime was valid. So Justice Thomas turned to what he called analogical reasoning. You'll remember the LSAT. They haven't got rid of that quite yet, right? The LSAT was this is to this, is this to this. Remember, we used to do this, right? We've all done this before. And this is how Thomas approached the Second Amendment. For example, he asked Paul Clement, the lawyer for New York, the lawyer for the plaintiffs, if we analyze with history, tradition, and text, we have to do it by analogy. And Thomas asked Clement if you can give me some regulation in history that would form a basis for the regulation today. What do we analogize it to? So the majority opinion sort of went chronologically. He looked throughout 4 periods of time. So first off, the court looked to medieval and early modern England. And there's a very famous statute called the Statute of Northampton from 1328. This law prohibited people from, quote, going armed. This law was enacted during the reign of King Edward III. It was in effect for King George I, King George II, King George III, Regina George, and so on. Regina George means Queen George, so it works pretty well. So during oral argument, Paul Clement said that the Statute of Northampton was a prohibition on either carrying unusual and dangerous weapons or using common weapons in a way that terrorized the public. But there was another way to read the statute. Barbara Underwood, who was a New York Solicitor General, said that carrying a gun would, by definition, per se, if you will, terrorize the public. Right? She said that guns were deemed to always be offensive weapons, therefore was always banned. So how do we deal with this, right? How do you deal with this sort of conflict? The court agreed with Paul Clement. The court said that the Statute of Northampton only prohibited bearing arms in a manner to spread terror. Now, it's true the Statute of Northampton was enacted in a number of the U.S. colonies almost verbatim without any changes. There was disputes over how often these were enforced, if at all, which gets to the question of how do we read history? How do we look at historical instances to prove what the right means in the 1790s? Okay. Next, Justice Thomas jumped ahead to the period of the American colonies and the early Republic. And during that period, there's little evidence of regulating public carry by the general public, even with states that had enacted the Statute of Northampton. Prior to the Civil War in antebellum America, state governments did enact restrictions on public carry. However, Justice Thomas observed, none of these restrictions imposed a substantial burden on public carry that were analogous to New York's May issue regime. At most, the manner of public carry was subject to reasonable regulation. They didn't have the May issue regime, right? Law-abiding citizens were not prevented from carrying arms for self-defense. Now we get to the Civil War and things start taking a bit of a turn. It's not disputed that Southern states violated the rights of freed blacks to keep and bear arms. This was a huge problem after the Civil War, as lynch mobs would ravage the South to try to kill people, and they didn't want the victims to be armed. But Justice Thomas writes that these racist Jim Crow laws were not reliable evidence of how the right to bear arms was understood. In other words, the fact that some people deprived this right doesn't mean the right failed to exist. One piece of evidence in 1866, Congress reenacted the Freedmen's Bureau Act. This statute expressly authorized the Bureau to protect the right to bear arms. This was listed among the paragon, the top rights that were deemed important by the Reconstruction Congress. According to Justice Thomas, limits of carry in other states were still consistent with the right of the public to peacefully carry handguns for self-defense. Now, the court turned then to the Western territories, and there's some evidence which supports, I think, the other side. You see these pictures from the Old West, deposit your rifle, deposit your gun with the sheriff when you enter this town. These pictures are everywhere. And the court, in candor, sort of brushes that off. He says, these appear as more as passing regulatory efforts by not yet mature jurisdictions on the way to statehood. These laws were not part of an enduring American tradition of state regulation. So again, how do you balance, hundreds of years of history where there's some evidence going one way, another evidence going the other way? Thomas concluded that on balance, American government simply has not prohibited the public carry of commonly used firearms for personal defense. Then we get to New York's law, which is over 100 years old. The Sullivan laws were enacted in the early 20th century, in part to keep the guns at the hand of Irish and Italian immigrants. This is part of the impetus for this law. Not that it affects it, but that's the origin of the law. So you have a 100-year-old law, which the court says is inconsistent with centuries of law before it. Okay. Based on this history, hilarious, I know. Based on this history, New York's May issue regime did not have an adequate historical analog. In light of this history, the court held that the proper cause requirement was therefore unconstitutional. All right. But the court didn't just stop there. The court said there are limits on this holding. And this is what you often call counting to five. If the Justice Thomas opinion was written by himself, the case would have ended right there. But to keep five, as in Heller, there's certain limitations. So the court did not cast doubt on the language in Heller about restrictions on guns in so-called sensitive places, so-called dangerous, unusual weapons, certain people who are mentally ill. They didn't repudiate Heller, so Heller was still good law. Thomas also did not cast doubt on the rules in the shall issue states, about 40 of them, which require certain objective indicia, like a background check or firearm safety course. But the court counseled that these regimes may be unconstitutional if put towards abusive ends, for example, lengthy wait times. I've heard in some California jurisdictions, they're waiting 6 months to a year for a permit. That's not going to work, even under the terms of Bruin. Justice Kavanaugh, as he often does, wrote a concurring opinion, tells what he really thinks. And he identified two other limits on the court's decision, none of which were briefed, right? Kavanaugh says that states can require mental health records check, which was not an issue in New York, but he just threw that in there. Can't imagine why. Okay? Kavanaugh also repeated the language verbatim from Heller about long-standing prohibitions of carrying firearms by felons and mentally ill, as well as laws forbidding the carrying of firearms in sensitive places. Again, there's no definition of what sensitive place is. Okay, so in the wake of Bruin, we're already trying to see what about misdemeanor, something short of a felony, a violent misdemeanor, or perhaps a person who has a what's called a restraining order for a domestic violence case that does not rise to a felony. That was actually a Fifth Circuit case from a few weeks ago. All right, the final part I want to talk about is actually the gun policy part, which played heavily in Justice Breyer's dissent. He had a lot of statistics, as he always does, about guns and public safety and mass shootings and the like. And Breyer criticized the majority for burdening the state's ability to reduce gun violence. Justice Breyer wrote that the state should exhibit modesty and restraint when they interpret and apply the Second Amendment. And I'll admit, there's some tension here, right? In the same week, the court decided Bruen and Dobbs. And this, almost, I think, back-to-back days, maybe 2 days apart. And in Dobbs, the court said we shall defer to the states on the issue of abortion. And in the Bruen case, well, we're going to be skeptical of the state's gun laws. And of course, you can reconcile it saying, well, guns are enumerated and abortions in the penumbras, right? There are differences between the two things. But these two opinions decided really within a couple of days of each other are somewhat in tension. And I think Breyer was sort of alluding to this when he referenced the this idea of modesty. Justice Thomas rejected this sort of modesty, as he often does. He says lots of constitutional rights have public safety implications. The criminal procedure rights can be dangerous. Speech can be pretty dangerous. But we don't limit them absolutely because of that. Okay. Thomas wrote the court should exhibit unqualified deference, not to the government, but to the people. The right of law-abiding citizens, responsible citizens to use arms and not to legislative interest. All right, so let me wrap up, and I'll turn it over to Steve in a moment. Going forward, there are a lot of issues that are sort of open. One of them is so-called assault weapons, which are guns that look scary, more or less, right? It doesn't actually relate to the power of the gun.
Scary.
No, they do. The defining features, the cosmetic features, that's what makes an assault weapon, right? Are these weapons protected? High-capacity magazines, things that go into these various weapons, are they protected? Then we get to scope of sensitive places. New York designated what it called Times Square as a sensitive place, which is almost like a 20-block area, which is a fairly large area. They actually posted signs around the perimeter saying no guns allowed. I walked around it, sort of take a picture of these signs. I didn't see many of them, at least back in September. Maybe they've been posted since. Another issue that comes up is the right of former felons to bear arms, as say Martha Stewart, right? Someone with a non-violent felony who should be denied a right to bear arms for the rest of her life. Then for the so-called violent misdemeanor, that's a misdemeanor that has an act of violence, which is usually less than 1 year in prison, although there's some wrinkles in that as well. What about restraining orders? People have not been convicted of a crime, but are subject to a restraining order. The last point I'll mention is methodology. No one, not a single Second Amendment advocate wanted what Justice Thomas did, right? This analogical reasoning. Go read the amicus briefs. No one urged him to do that. And I'll admit, original scholars are sort of struggling with what to do with this. Steve's laughing. I'll let him laugh, right? No, we are. I'm being candid. I always try to be candid with my audience. It's not what anyone asked for, right? And I think the key move is how tight must the analogy be, right? How closely related must a current day regulation be to some historical analog? I'll just give you an example, I'm sure Steve will raise, which are surety laws, okay? In the 1700s, 1800s, some states had what's called a surety law. That if you posed a threat to someone else and you want to carry a gun, you have to basically pay money to the state, to the government, and they would hold your money. And if you use that gun for evil, they would use that money to compensate damage. It was a surety, like a bond, if you will, right? It's not clear how often these laws were ever enforced. And even if you actually pay the surety, you can then carry your gun. Is this a good enough analogy to support a Maoist regime? The dissenters in Bruen said no. The majority opinion in Bruen said, the dissenters in Bruen said, yeah, this is good enough. But the majority said, no, it's not good enough. And this is at bottom in normative judgment, right? How close of a fit must there be between history and the present day practice? I think the Thomas opinion is probably leaning towards the broader side, but I suspect as cases trickle back up, the court will narrow it. So the violent misdemeanor case I mentioned, Fifth Circuit, I don't think that stands, at least the Supreme Court. Maybe Steve would agree with me on that one. I think they're not going to be 5 votes for the Circuit's position, but we'll see. All right, thank you all so much for your attention. Welcome to Steve's comments, and I appreciate your eager rapture applause later. Later.
Where to start? Okay, so I am a bit of an idiosyncratic progressive when it comes to the Second Amendment. I am not sure that Heller is wrongly decided, even though I think Scalia's opinion is in numerous respects indefensible. And I think that's important context because it seems to me that you can think Heller is right as rain and think Bruin is an incoherent, indefensible mess. And I want to suggest that indeed Bruin is an incoherent, indefensible mess. So Josh alluded to the Fifth Circuit's decision earlier this month. I want to start with the Fifth Circuit's decision earlier this month in the Rahimi case, where the Fifth Circuit struck down Section 922G8. This is a provision that says that you cannot possess a firearm if you are currently subject to a domestic violence related restraining order. And if you read the statute, it's pretty specific about what that means. It means that a court in a hearing to which you had notice must have found that you pose an ongoing credible threat to an intimate partner or the child of an intimate partner. And the Fifth Circuit says, well, that's all well and good, but alas, there's no historical analog for laws restricting firearm possession by those under domestic violence restraining orders. Of course, domestic violence restraining orders are themselves not exactly a founding era principle. If we might remember, among other things, that at the founding era, women didn't have rights. Small detail that gets in the way of trying to draw historical analogies. Similar, right, we had the district court's decision holding that it was unconstitutional for Congress to require serial numbers on firearms such that the defacement or destruction of a serial number is unlawful. No, that violates the Second Amendment because serial numbers were unknown to the founders. Right? This is the kind of analysis that Bruin leads district courts to perform. And it seems to me that one of two things is true. Either these rulings are consistent with Bruin or they're not. And given how many of them there are, I think it's increasingly hard to argue that they're not. Given how malleable Bruin is, I think it's increasingly difficult to argue that they're not. And so to me, the fault lies not in how lower courts are applying Bruin, the fault lies in Bruin itself. So let's talk about Bruin. So a couple of things about Bruin that Josh didn't mention in the summary. First, the court in Bruin rewrote the question presented. Right? Rather than actually deciding the question that the plaintiffs wanted the court to decide, the court rewrote the question to decide the question that it wanted to decide. It's not the first time the court has done that, but I still think it's worth reminding folks that the court does that sometimes. Second, I think Josh did agree on this point, that the court decided a heck of a lot more than it needed to. That even if the court was inclined to strike down New York's May issue regime, it would have been very easy for the court to do so under most, if not all, of the then pertaining tests that had been adopted by lower courts after Heller. Right? You could have said, right, this is unreasonable under the circumstances. This fails intermediate scrutiny. This is not significantly tailored, right, to the underlying justifications for the law. Indeed, given the way New York enforced its regime, you could have argued that New York's statement of what its important interest was actually not correct, much like the California in the Michael M. case 30 years ago. Right? The court says it's getting rid of means end balancing, but never actually explains why means end balancing is problematic. Right? Never explains what's wrong with the approach lower courts have taken. Just asserts, right, that it's inconsistent with the text of the Second Amendment, text that I think I don't have to tell this room is open to some interpretation. Exactly.
That's perfectly timed.
So Jonathan knows. The two other points about Bruin before I turn to sort of why I think it's so problematic. Fourth, Bruin constitutionalizes Heller's deeply contestable version of the history here. Let me just give you an example. You can try to read Justice Thomas's opinion in Bruin and find exactly which historical period is the relevant one for identifying appropriate historical analogies. Here are some candidates. 1791, when the Second Amendment was written and ratified. 1868, when the 14th Amendment was written and ratified. Does the court in Bruin tell us which period is the relevant period? No. Right, which allows the court to say New York's more than 100-year-old law lacks historical analogs. I would say New York's law is a historical analog to itself. But what do I know? I am not a professional historian, and neither are they. Right? 5, I think I actually did hear Josh say this. What Justice Thomas did in Bruin with this history and tradition approach doesn't even remotely resemble originalism, as just about any modern expositor of that methodological commitment would define it. Right? The only way that you could defend Bruin as an originalist opinion is by persuading the reader that in 1791, when Congress proposed and the states ratified the text of the Second Amendment, it actually meant to enshrine this historical analogy hunting, right, that Bruin contemplates. As debatable and contestable as the founding era evidence of gun ownership is, I'm not aware of any founding era evidence that this is what the Second Amendment intended, and I didn't see Justice Thomas Marshall any in his opinion. All right, so let's talk about historical analogs. I think we agree that historical analogs are subjective. Two judges can look at the exact same historical analog and find them more or less convincing. Let me just read to you how the Fifth Circuit dealt with the federal government's best historical analog in Rahimi in the domestic violence case. Right, so federal government says there are lots of founding era laws that categorically prohibited people who were dangerous from gun possession. The idea being that if you're dangerous, we don't really want you to be able to walk around with guns. Crazy idea, I know. Right? This is what the court says. Despite some facial similarities in how these dangerousness laws worked, like the domestic violence statute, they operated to disarm covered people. There were also material differences. For one, they disarmed people by class or group, and not after individualized findings of credible threats to identified potential victims. Even more, why they disarmed people was different. The purpose of these dangerousness laws was the preservation of political and social order, not the protection of an identified person from the specific threat posed by another. In other words, right, what the Fifth Circuit is saying is the problem with the historical analogy is this is too specific an example of the broader thing that was prohibited at the founding. Think about that for a second, right? Like the problem with the analogy is that this law is more specific than the one that applied at the founding. If the question is, could legislatures prohibit people in similar circumstances from possessing guns, the idea that the current law is a subset of the older law seems to prove that the answer is yes. And yet the Fifth Circuit says actually it proves the opposite. Right? In that universe, we're not asking for historical analogies, we're asking for historical congruence, where it is literally one-to-one parity, right, between what the current law does and what was available historically. Ironically, imagine if it were reversed. Imagine if Congress says, oh, okay, Fifth Circuit, you want a broader restriction? Fine, we will categorically disarm anyone who is dangerous without a case-specific finding, right? Without some individualized determination that they pose a threat. Is that better? Right? I would think that's a due process problem at that point, even if it's not a Second Amendment problem. So this is where we are in the world under Bruin, right? Why they disarm people was different. The purpose of these dangerousness laws was the preservation of political and social order, not the protection of an identified person from the specific threat posed by another. Yes, preserving political and social order by preventing deaths of people through these kinds of episodes. Right? I mean, if you guys haven't looked at the statistics on how much a handgun or firearm increases the odds that the victim of domestic violence will die, right? I think it's by a factor of 5, right, according to most recent studies. Okay, it's not also how historians do history, right? So Josh quoted Justice Thomas's discussion of how the question for courts is to consider the parties' historical arguments and decide which argument is stronger. Can you imagine if that's how historians resolve debates? Like, what caused the Civil War? Well, they say slavery, but they say agrarian pressures and economic upheaval. We're more persuaded by the agrarian pressure economic upheaval argument, therefore we discount the slavery argument, right? That's not how history works. And so even if we're not going to appoint historians as amici to argue these cases, let's not pretend that what we're doing is history. And let's not pretend that this is history. This is barely even law office history. Okay, my favorite example of this, though, is, as Josh actually alluded to, in Bruin, when Justice Thomas talks about the Reconstruction era laws, where Southern states disarmed formerly enslaved people, and Thomas is like, oh, those aren't good examples because those were mean, right? And those weren't the norm. Those were just Southern states being hostile to Black people. Aren't those examples of laws that disarm people in the relevant time period? right? So if you can wave your hands at historical analogies, not clear to me what work historical analogies are actually doing. Okay, what this really though gets to, and what to me is the most problematic feature of Bruin, is the difference and the daylight between Justice Thomas's approach to the Second Amendment and Justice Scalia's, right? One of the things that Justice Scalia says expressly in Heller is that the Second Amendment is not an absolute right. Right? There are no absolute rights in the Constitution. There isn't a single constitutional provision that creates an individual right that the government is never allowed to infringe upon. Even the writ of habeas corpus, right, can be suspended in cases of rebellion or invasion where the public safety may require it. Okay? There is this mindset that has been out there for the last 13 years since McDonald that lower courts have treated the Second Amendment as a second-class right because they haven't given it absolute status. But there are no rights that have absolute status. And so whereas Heller left open hard and difficult questions about what kind of interest governments could show to justify infringing upon the Second Amendment right to keep and bear arms, right? Bruin pushes us much more closer to the absolute right that Justice Scalia condemned. Okay. Now, Josh says, well, Bruin says we're not talking about sensitive places. Okay, what are sensitive places? Guess what? It's time for historical analogies for sensitive places. Are sports arenas sensitive places? Well, we didn't exactly have the Moody Center in 1791. That would have been really impressive, right? So if we're doing those kind of analogies, no, sports arenas, hard to say they're sensitive places. Airports, you guys see where I'm going with airports, I assume, right? No airports. Right? So you might say those are dumb analogies, and I would say true, and that's where we are. Right? So it seems to me that the burden is actually on the Supreme Court to take up one of these cases, whether it's the domestic violence case, whether it's the 4-3 division among district courts about whether the statute making it a crime to be under a felony indictment and in possession of a firearm violates the Second Amendment. It's a 4-3 split where 7 different district judges have looked at the same historical analogies and reached almost 7 different conclusions, right? Seems like the burden's on the court to clarify what they mean and to clarify exactly what kind of right the Second Amendment is. Because if the Second Amendment is an absolute right, then I think we should start wondering whether other rights are as well. And the last thing I'll say about this, just before leaving it back to Josh, part of the reason why I have idiosyncratic views about the Second Amendment is because of a series of Supreme Court cases that are not Second Amendment cases that have refused to recognize a federal constitutional right on the part of any of us to government protection, right? So my not favorite example, but the most sort of visible example, this is a case from 2005 called Town of Castle Rock versus Gonzalez. Jessica Gonzalez had a restraining order out against her former domestic partner. She called the police multiple times to try to get the police to come when the domestic partner was threatening to kill her and her children. Police did not come. She kept calling them. They kept saying, we're too busy, even though they weren't. They actually were not busy that night. Right? The former domestic partner kills Gonzalez and her 3 children, right? And her family sues. And the Supreme Court says, sorry, tough noogies, you had no right to have the police come and protect you, right? So my view is, well, in that case, it actually might make sense that people have a Second Amendment right to protect themselves, right, if the government can't protect them. But then turn around and look at Rahibi, which says that but the government also can't disarm the domestic partner who's under a domestic violence restraining order. That to me is an invitation for violence. It's an invitation to unnecessary death. And it's an invitation that's not required by the Constitution or common sense. Thank you.
Thank you. Thank you so much, Steve. You can clap. Go ahead. Thank you. So I think there's a lot of agreement, but for very different reasons. But I do like agreement. So I'll start off with the recent decisions involving the violent domestic violence restraining orders, the serial number cases. I don't think there are 5 votes to affirm this. Whether Bruin itself could read that broadly, I think if it goes up, I think that gets down to maybe 4 votes, maybe 3 votes. So there will be a blip. There will be a period of adjustment.
Can I ask you to be clear on what this is? The 5 votes to affirm this.
I meant the ruling on the violent restraining orders and the serial number cases, the 2
Both
cases.
of them. Okay.
No, I don't think either case stands up. Both of these sorts of cases. But maybe explain, why did Justice Thomas sort of go so far on a limb here? For nearly a decade, Justice Thomas, and for a time Justice Scalia, was dissenting from the denial certiorari in case after case, saying, hey, Supreme Court, we decided Heller, let's pick another case. anything. And for a decade, almost 12 years, the court denied every single case on the Second Amendment. And during this time, the lower courts adopted what perhaps we called intermediate scrutiny, some sort of middle scrutiny, whatever you want to call it. But by and large, almost every gun control law survived. There were a couple outliers here and there, but in the Ninth Circuit, in the Seventh Circuit, no case in the Fifth Circuit, they didn't bring them here, but just about every other circuit, the laws were upheld. And Tom was saying, let's take a case to clarify it. And for a decade, the court said no. In hindsight, we can guess because maybe Justice Kennedy wasn't on board, and these were defensive denials. The court didn't want to take a case in which Justice Kennedy would vote to uphold the gun law. They preferred the sort of weird status quo. But I think Thomas saw this sort of defiance, if you will, of these lower court decisions as something very bad. And he didn't want to hand them another balancing test they could use to manipulate. So he tried to create a test to operationalize the Second Amendment that would make it very hard for them to strike down laws. Hence this congruence, if you will, this analogy. In other words, he knew what he was doing, right? Justice Thomas, but he knows what he's doing. I mean, he was trying to make a test that would be very hard for the lower courts to abuse. But in the process, I think perhaps his colleagues went along with it, and maybe they probably will have some second thoughts later. Okay. Now I want to talk about originalism, right? What exactly is the originalist enterprise? In other words, what is it that originalist judges, originalist scholars are trying to do? And I hear this argument a lot. Historians disagree. Historians are doing something different. And I think something very important. They're trying to look at broader historical context. How did various political forces, cultural forces, religious forces come together, and they sort of tell a story, a narrative of what was going on in this period of history? I think the legal inquiry is different, right? Lawyers are doing something different than historians. Lawyers are trying to give meaning to constitutional text. So let's say we agree, maybe we do, that the right to bear arms protects outside the home. Okay, what do you do next? In other words, if this is such an easy issue, how come the Second Circuit for years upheld that the New York gun control law survived, right? If this is such an easy issue, how did New York's law keep getting upheld, right? So if there is a right to bear arms, how do you actually operationalize it? What do? Do you simply say, well, we will simply use intermediate scrutiny? Okay, fine. What does that mean? Is there a relationship between the means and the ends? Okay, that's all great. But at some point, you're going to have to take a normative judgment, right? Who has the burden? Is the burden on the individual, or is the burden on the government? Right? That's always the basic question in government litigation. If the burden is on the individual, guess what? You're probably going to lose. Right? If the burden's in the government might lose. Okay, then after you assign the burden, you say, how big is that burden? Right? What do you have to show? Well, the government have to show, is this something that you have a really good reason for? And with guns, they can probably make that case. Violence, statistics, right? They make the case. But Thomas put a different burden. He said, look, it's not just enough that you have to show you have a good reason for it. You have to show, is it something that's been done before? And this gets to the question of specificity. You're looking, as Steve mentioned, the big picture. Were the regulations on guns? Yes. Or was there the exact same one-to-one congruence between the law at issue today and the law at issue in the past? That sort of test, I think, will always fail. Because if you've done something you've done in the past, no one's going to challenge it, right? The reason why they're challenged is doing something different than was done before, right? Whenever there's something new, you're breaking that congruence. So I don't know how Thomas is going to justify it. And I'll tell you a dirty secret, and Steve might agree with me on this one. Even if the court says there's no means and balancing, there's going to be means and balancing, right? No matter how you slice it, the court will have to decide, does the government state a sufficiently weighty interest to accomplish this goal, right? That will always be lurking in the background. And number two, how broad is this regulation? In other words, is this regulation broader than need be? So the dirty secret is, I think this historical inquiry will more or less resemble strict scrutiny. After all is said and done, you can't use the word scrutiny. That's a dirty word now. We don't talk about scrutiny. We don't talk about Bruno, right? We don't talk about these things. But I think that what they're doing is basically strict scrutiny. And there weren't votes for that. We know Justice Kavanaugh doesn't like the word scrutiny. Justice Kennedy hated the word scrutiny. They don't like scrutiny. That's a very Brennan-Berger-esque test, right? We don't talk about scrutiny anymore. Indeed, Justice Thomas said that the First Amendment, free speech, is historical. That was news to me, right? Go take a class in First Amendment. It's a shamble of jurisprudence. So perhaps maybe the court's trying to shift away from scrutiny writ large, and Heller is just the first, not Heller, Bruin is just the first stopping point. But look, we have to wait and see. It took us a decade to cash out what Heller actually meant, with 4 or 5 new justices in the process. And I think in the next couple of years, we'll see what Bruin shakes out as. And maybe the Fifth Circuit case on the restraining order doesn't stand. Maybe the what are called the nonviolent misdemeanors. You engage in Social Security fraud, right? That's an easier case, right? Is there actually a propensity for danger? All right, we're at 12:40. I will stop here. Let's see if I have some words, and I welcome your questions later. Thank you so much.
So if this is strict scrutiny, Rahimi is wrongly decided. Because in Rahimi, you have a compelling interest and you have narrow tailoring, right? You can't violate 922G8 without a court already having found that you specifically pose a credible threat of violence and harm to an intimate partner or their child. If that's not narrow tailoring, I'm getting out of the common law business. No one in the Fifth Circuit, neither Judge Wilson's majority opinion nor Judge Ho's concurrence, where he was pleased to join in Judge Wilson's majority opinion, says a word about the government's compelling interest. No one in the Fifth Circuit says a word about how narrowly tailored 922G8 is to fulfilling the government's compelling interest. And so, maybe Justice Thomas secretly meant to send the strict scrutiny bat signal to the lower courts, but they didn't get it, if so. So if Josh's position is that the Fifth Circuit's Second Amendment jurisprudence is now wrong, I heartily endorse it. To the broader point about originalism, Josh says we're making a normative judgment. I guess I must be confused about what originalism is then, because I had thought for all of these years of my misspent days as a non-originalist, that the whole purpose of originalism was to suggest that there was one single objective, definable and discernible understanding based on the original public meaning of the text of the Constitution about what the Constitution actually protects. Seems to me that there's no room there for normative judgments, right? Normative judgments are necessarily going to evolve because norms evolve, right? And because our understanding of what is dangerous and what is not evolves. So if what we're really doing is making normative judgments about the relative strength of the government's position and the relative weakness of the regulated person's position, we're not doing originalism at all. And if the real lesson here is that Justice Thomas is actually a living constitutionalist, well, I can also agree with that. The last thing I'll just say is, listen, there's no question that the debate over gun control gets everyone's dander up. It's hard to look at recent events and not be of that view. The ultimate question is, much as the Supreme Court said in Dobbs, who should decide, right, what the right rules are in this context? And I guess I would just end with the idea that if we're not doing originalism, which I think we've now conceded we're not really doing.
I've not conceded.
Well,
go ahead.
I will say most of the other prominent originalists have conceded Bruin is not really faithful to originalism that they've constructed it. Then it seems to me that we've lost the justification for treating the Second Amendment any differently in this space than the Supreme Court treated the right to abortion the day after Bruin. If we're returning that to the people because there's no plausible, coherent, originalist defense of the idea that the Constitution protects the right to a pre-viability abortion, seems to me that there's no better argument for not doing the same with guns. Thank you.
Okay. All right. I'd love to take some questions from students.
We've answered them all. Jonathan.
So on your especially the original my question is sort of on like this issue of like actually synthesizing, which seems to come into play in like, and whether or not this issue is based on the fact that we're trying to construct like the history of the United States. The United States sort of finds itself on being like a bunch of disparate states sort of moving at their own pace and operating at their own position. So is it possible to really construct that pure, tried and true construction of the United States, or is it sort of there's a give and take? This is the most like.
And I guess my response is I think it's possible, but it's going to be a mess, right? I mean, like it's going to be right. So do a 34 state survey, right, of the laws relating to firearms in 1867, right? And guess what? You're going to get 34 different answers. And you're going to get different answers about what the restrictions look like, about who could be restricted, about when they could be restricted. And my reaction to that is great, right? Laboratories of democracy, or not democracy in the case of 1867, right? In that context, if we're doing history faithfully, the admission we have to make is that there was no single uniform national understanding of what could or could not be regulated, which would then, to me, give the Second Amendment less compass, right? If we're applying a pure history and tradition test. I don't think we should be applying a pure history and tradition test, right? Which is why I think that fraught historical enterprise is ultimately not going to be successful. But if we're going to do it right, I think we have to understand that it's going to produce a very noisy answer in most cases, if not all. And I don't know how you write around that, right? I mean, we saw what Thomas did. Thomas says, oh, the post-Civil War laws banning freed slaves from possessing guns. Those were aberrational. Like, well, how can you say some historical examples are aberrational and some aren't? They're all examples, right? So that to me is the problem.
Well, let me ask the question a little bit differently. Pretend you're an originalist judge, or a couple of years you're clerking in the Supreme Court. Mazel tov. Congratulations, right? You're not writing on a blank slate, right? You have 200 years of precedent. You have centuries of statutes in the books, and you have 4 colleagues who may not agree with you on everything. Writing an originalist amicus brief or an originalist law review article is one enterprise. Writing an originalist majority opinion to be interpreted by hundreds of lower court judges is a different enterprise. So when I say there's a normative judgment, that's referred to as the operationalize or synthesize, to use Jonathan's word, right? How do you actually synthesize an originalist argument to an opinion that can then be enforced by many different actors? That's, I think, what Justice Thomas was trying to do. Think of Heller. The sensitive places stuff was just made up. Maybe it was just Kennedy or someone else to get 5 votes. The dangerous, unusual weapons. That entire paragraph was added, it seems, to keep 5 votes. Do you think Scalia wanted that in his opinion? If he was writing a blank slate, probably not. Probably holding his nose in that paragraph, right? You have to operationalize a law. So an originalist judge, of course, should follow originalism. I think that gets you the point that there is a right to bear arms outside the home, and a Mace regime is not consistent with that right. Fine. But then what do you do with it? And this is what maybe Randy Barnett might call construction, right? There is a part of originalism that does involve some normativity. And it's something original scholars argue about till the end of time. But you cannot be a judge and write an opinion and actually expect to get 5 votes. You have colleagues. Not all of them are as hardcore originalists as Justice Thomas is. And this is what I think is the byproduct. And we'll take some time to hash out what we do with this opinion itself.
So in other words, Thomas is a pure originalist, but to follow Brennan's rule of 5, he had to sacrifice his principles.
I think we're in a multi-member court, right? You have give and take. And I know that Thomas is a pure originalist. I think there are things of his that I don't always agree with. But you have to have an opinion that can govern the court. And whether you call it the rule of 5 or the fact that you're in a multi-member court, you have to have a consensus in some regards. That's how law is governed. That's how opinions are written. Other questions?
Was not limited to hunting or even self-defense. How does that change sort of what our limiting principles should be in regards to what the government is allowed to regulate when the purpose of the Second Amendment was less than favorable towards the government?
So, I mean, I think it's very true that the idea that the Second Amendment exists, at least in part, to give the people a means of standing up to a tyrannical government should be an important part of our analysis. I guess what I come back to is I have not yet been persuaded that means and balancing can't satisfy that, can't vindicate that understanding, right? Because it seems like either you believe the government never has an adequate justification for regulating firearms, or you believe that there are at least some circumstances in which it does. And if you're in the latter camp, as frankly I think most people are, we might disagree about which circumstances, but like some circumstances, then it seems like what we're really just fighting about is not the underlying principle or the purpose. We're fighting about the application of the margins, right? So we might all agree that, like, no, you shouldn't be able to bring a firearm to a Supreme Court argument, right? Like, that's low-hanging fruit, right? I think maybe we don't agree about that, right? But my point is that it's a line drawing problem, not a principle problem, right? And so once you accept that the government has some room to regulate firearms, then we're just fighting over like how strong of a case they have to make. To Josh's point about strict scrutiny, I guess what I would be like much more comfortable if the court just came out and said, right, because of the history and the historical tradition, we want to err on the side of protecting the right, and so we're going to hold the government to an especially heavy burden, but it's going to be an objective one, right, and one that like we expect lower court judges to apply consistently and not based on their own experiences and prejudice. I mean, just guys, think about it this way, okay? Imagine two different federal district judges. One who grows up in Texas, right, who owns a gun from the time they're old enough to own a gun, who goes out shooting, once a month, right? And one who lives in inner city, I don't know, Chicago, right? Who has never touched a gun, who doesn't have guns in the home, who doesn't think about guns, right? They're going to have very different life experiences informing them about what the right arguments are. I would rather disempower their experiences from having value, right, in the analysis and make it turn on objective factors that two different judges from different walks of life are going to apply equally. And if that means sort of disfavoring the government's interests to a degree that we don't usually do in other rights, I think that's worth it compared to this.
I think the question is going a little bit differently. If the purpose of the Second Amendment is anti-insurrection, right, is basically the right to fight against the government, what type of arms are we protected? Is that where your question was going?
That's part of it,
Yeah. Right. So it ain't about handguns. It's about the bigger stuff, which would be very different than what we are today.
Right. I mean, no one. Right. There's no context in which any person today is going to have the arms necessary to actually stand up to, the
Uh,
army.
Other insurgencies may disagree. Fallujah and other places, insurgents have been pretty effective. I mean, Ukraine had small arms fighting the Russian army. They lasted, well enough for a bit. All right.
Okay,
Well,
good luck with that.
yeah, good.
I mean,
Good luck with that.
but okay, but then,
Well, we're mustering in the quad after class, everyone.
but hold on a second. But then we're back to absolutism, right? And so if your goal is to make the Second Amendment absolute, just say so. Like, stop beating around the bush and saying no, it's about history and tradition. Like, just say we want the Second Amendment to be absolute. It's unique among constitutional rights. We have no historical argument for why it's absolute, but we just think it should be.
Are we going to time it if we finish at 50 or at the hour? Okay, the question over there, please.
And
Because like the laws and procedures are also encompassing by like the historical norms and norms that were not written in law, but that were the
Good question. I think it's actually a very good question. There's one way of looking at it is laws were often the books were not enforced, right? And how much weight do you give a law that was on the books since the 1300s that was never enforced? This is perhaps the Statute of Northampton, or the surety laws, which were on the books, but there's no evidence they were actually enforced, right? Your second part of the question, I think, is actually very good. Norms, right? Even if there was no written law, was there some sort of social convention that you didn't do this with a gun? And I don't think Thomas's opinion addresses what weight those such unwritten policies could be. How much weight those unwritten policies should receive. It's a good question. I don't know.
but if the burden's on the government to provide examples, how are norms examples? I don't see how that works. I mean, like, if the burden's on the government to walk in the court and say, here, judge, here are specific examples of legal prohibitions on the possession or usage of firearms that are analogous to this case, I don't know how the absence of physical evidence of such analogs could ever satisfy that test.
I don't know. It was a fun question. Never heard it before. But if there's certain norms that perhaps could rise to the level of quasi law, maybe it could. Probably not. I'm not sure.
I mean, I just think that's inconsistent with putting the burden on the government to produce examples.
Okay. Thank you for the question.
So obviously, Bruin's going to spur a lot of litigation. A lot of pro-Second Amendment organizations have already started using Bruin to challenge some more or less long-standing laws like the NFA. What kind of
National Firearms Act, if you know the acronym.
Sorry. What kind of which set of these different strains of ongoing cases or cases that will be brought do you think the Supreme Court will take up and clarify how close the analog and historical analog must be?
Look, so let me put it this way: if I was litigating these cases, which I actually do, my preferred vehicle would not be Rahimi, the violent misdemeanor case. My preferred vehicle would be a challenge to a white collar crime, right? I think that'd be a very good place to start. The Martha Stewarts of the world, right? Why are you disarming? There's an article. Why can't Martha Stewart own a gun? There's an article, right? I would pick a non-violent misdemeanor case. I would also want to bring a case where you have these jurisdictions basically dragging their feet. Like again, I heard in some California jurisdictions they're waiting 6 months for a permit, or they're charging extremely high, not fines, but fees, but those hundreds of dollars a year for these various checks. I would actually litigate the mental health check, right? There are certain privacy issues at play of why you may not want the government knowing if you had a depression diagnosis 25 years ago. If you got a one diagnosis of Prozac a quarter century ago, that means you can never own a gun. In New Jersey, there's actually a cottage industry of shrinks who just write you a note, but they charge a lot of money for it. It's a booming industry. So I would want one of those cases at the margin. There are other cases involving, gun braces, restrictions on so-called bump stocks, 3D printed guns. Our friend Cody Wilson's here, right? Hey, Cody. Right. So there are lots of cases which I am indeed litigating, but those are probably not the first case you want to go upstairs.
So I don't think it's going to be up to Josh and his friends. I think it's going to be up to the Solicitor General, because these laws keep getting struck down by lower courts, and so the party that's going to be petitioning for cert is not the challenger; it's going to be the federal government. And if I'm the federal government, Rahimi is a very good case for me because it's not a violent misdemeanor case, as Josh just said.
I'm sorry,
it's a
restraining.
domestic violence restraining order case. And if Justice Kavanaugh and Justice Barrett want to sign on to a majority opinion that says Congress lacks the power to ban people subject to domestic violence restraining orders for possessing firearms, if I'm the Solicitor General, I want to force them to do it. So it seems to me that the question is not going to be which challengers are able to bring which cases to the Supreme Court. It's going to be which cases the SG brings and whether they're able to get votes for cert at that point.
Cody?
It seems liberal justices have used the threshold inquiry of the liberal text of the amendment to basically prevent historical analysis from happening before. So I wonder if you could talk about that as a counterattack to Bruin.
You mean the militia part?
No, I mean literally, like Judge Wu in California says, well, if it's not literally in sheep and bear or it's not in arms, I don't have to perform the historical analysis, go home.
Right. So I don't know that exact opinion, but I think in general, a lot of judges who have long been sort of skeptical of Second Amendment rights haven't really changed the skepticism. Now they're sort of couching it in Bruin's test. And for example, Judge Reeves down in Mississippi is looking to appoint an expert. And other judges sort of looking at the history of the surety laws, saying, with these surety laws, that's enough. And they want to be super literal. I think in general, judges who are sort of hostile to originalism are going to turn to this tact. I can perhaps point to one in DC that you may have seen. There was a case involving obstruction of abortion clinics. People were blocking entry to clinics, and there's allegations of violence, right? It's the FACE Act. This is an excerpt of Congress's commerce powers. Okay, so we have Dobbs, and a federal judge in Washington said, well, Dobbs said the 14th Amendment doesn't protect the right to abortion. But what's the 13th Amendment? Maybe it's more of involuntary servitude or slavery. Brief that. So I think a lot of judges who, again, are hostile or perhaps skeptical of originalism are going to sort of make people go through the paces of putting forward this information as almost like defying the opinion, hoping they perhaps don't get caught. But I think the sort of literalism you mentioned wouldn't stand up. But then again, I think Judge Wu's in California, if memory serves. So the Ninth Circuit, I think, as an automatic rule, any panel opinion in which the gun control law is struck down is automatically en banc. It's a circuit rule. So there's not much to it.
So one, that's not true. Two, Judge Collar-Patelli's opinion is not about the Second Amendment. And three, ordering briefing is not defying the Supreme Court.
Okay.
Or is it?
I think the way she read Dobbs is very close to ignoring it. If you read
Has she issued an order that actually binds the parties based on her interpretation?
No, but lawyers aren't free. People have to pay money. It's actually a cost on the parties. These are criminal defendants being put through this extra burden. I think it's not nothing. If we have all these laws from 1868 saying you can have a right to abortion, the 13th Amendment was ratified only a couple years earlier. Anyway. So.
Well, if we're going down that rabbit hole, the laws from 1868 are about quickening and not about abortion, or at least some of them. So if we're going to have that debate, let's have that debate. But again, right, it's almost like history is complicated, and it's hard to just say, oh, here's one example from 1868, therefore this is the answer.
All right. What other questions you got? Yes.
You mentioned that Thomas had to balance like everyone's different opinions and one their opinion. Can there ever be a pure originalist opinion if judges have to do this?
No, I don't think there can be. And it's, I think it's a fact of life. I mean, we often speak there's a disconnect between original scholarship and originalist judging, and they're not always the same. You might see it in a concurrence, right? Because a concurrence is just a solo judge expressing his or her own opinion. But I think when you have a 5-member court, are there 5 originalists on the court? Maybe if you squint hard enough. Justice Thomas would say yes. Justice Barrett said yes. Justice Gorsuch said yes. Justice Kavanaugh kind of squished at it, right? The Chief Justice said, I have no ideology. Justice Alito calls himself a pragmatic originalist, whatever that is, right? So again, even with the most conservative court since the New Deal, right, I think you still have pragmatism, right? And I think you have to live with that. And you have to then, you can criticize an opinion, but I don't think that's repudiation wholesale of originalism as a theory.
I'll just say, I mean, if your position is that originalism, that the allure of originalism is that it provides a single objective answer to the hardest constitutional questions, the idea that the Supreme Court is not actually reaching that answer in opinions that are put out as originalist is a pretty important, I think, concession.
What else we got?
Probably like one quick question.
One quick question. You want to go again? Yeah. Yeah, so Justice Barrett wrote an opinion on the Seventh Circuit in her brief tenure, addressing this. She actually had a dissent, and there's a guy who engaged in some sort of government fraud. I don't know if it was Social Security fraud or some sort of government fraud. And her opinion, I think, was very thorough, showing that the reason why people were disarmed was because of a violent felony, right? That non-violent felonies were treated differently for purposes of these rights. So I think there's actually a very good historical argument here. This is why the violent restraining order case thing is actually probably, I don't think that's going to stand up. Especially Barrett's opinion seems to say that violent people can be disarmed. That's why I think she's probably right about Barrett on that point.
Steve's probably right. It's a great place to end.
I think so too. All right, thank you, Steve.